Hey folks, I'd like to do a deep dive today into the recently passed legislation down in Columbia. It's House Bill 3430. It is the new tort reform bill that was passed through both houses. And I want to take a moment and go through each section of this bill so that you folks understand how it affects your rights as a citizen here in South Carolina. The bill that was ultimately passed was a much narrower bill than what was first introduced in the Senate way back in January. So I'm just going to go through section by section and address how the law is different from what it used to be. So first of all, the first section of this bill, as it relates to joint and several liability. And all joint and several liability means is that people who are found unanimously by a jury to be responsible for a victim's harm are responsible for the whole harm, regardless of whether they're 20% at fault, 50% at fault, 90% at fault. They're responsible for the whole judgment. That's what joint and several liability means. In South Carolina, we don't practice that. We have practiced for 20 years something called modified joint and several liability. And it basically means to be responsible for the whole judgment, you have to be more than 50% at fault amongst everyone who caused the harm to the victim. Otherwise, if you're 20% at fault, you just pay 20% of the victim's harm. So that's what we've been living under for the last 20 years. But there were a few tweaks that were needed, specifically when it comes to the sale of alcohol. So Section 1 of the new bill, what it does is it deletes the exceptions from modified joint and several. And what that means is it deletes the words grossly negligent and it deletes the words use, sale, or possession of alcohol. So what does that mean? Well, you may have heard people in the hospitality industry say, hey, if we're 1% at fault, we're responsible for 100% of the harm. Well, this bill fixes that. That is dead. There will never be an instance where a bar will be responsible for 100% of the harm to a plaintiff if they're found by a jury to only be a small percentage of the fault. Going forward, they're only going to be responsible for a percentage of the victim's harm. So that's the first thing it does. The second thing it does is it allows defendants in a lawsuit to point the finger at somebody else and try to blame somebody else for the victim's harm. And so what that means is if you're sued and you think somebody else is responsible, you can file a motion with the court and say, hey, I didn't do it, Jimmy did it. I want Jimmy to be put on the verdict form for the jury to consider and apportion some percentage of the fault to Jimmy because he did it. There's some rules around how you do that, the timing of that, and then there's some exceptions. If the injured victim can't sue the third party, then you can't point the finger at them, right? So it's just one of those rules. If they're immune from suit, then they can't be put on to the verdict form. So that's really Section 1 and how it changes our joint and several laws. Really what it does is it brings the hospitality industry in line with every other industry in South Carolina under the modified joint and several system. So Section 2 is a change to our liquor liability statutes. And it was really just a quirk that needed to be fixed. And it includes the word or inserts the word knowingly. And what that says is if you knowingly sell liquor to a patron, then you have violated the law. And that's a criminal offense that can render you civilly responsible or criminally responsible. So we wanted to insert that word knowingly so that there had to be some level of culpability on the person selling the liquor. It's not just strict liability. Section 3 is a long section that deals with alcohol server training, which I think everyone agreed was a good thing. This requires bars and restaurants to have their bartenders certified and to recognize, hey, this is what to look for when somebody's grossly intoxicated. You shouldn't serve them alcohol. Here are the dangers of serving alcohol to drunk people. This is why it costs lives. And it's really just to make South Carolina a safer place. So that's what Section 3 does. And that's a new thing. That's a new thing that was not in the law previously. It was not required, but it will be required going forward. Section 4 is some offenses. If you violate the alcohol server training statutes or are found civilly liable, then for a first offense, bars and restaurants are going to get hit with a $2,500 fine. Second offense, within 2 years, they can have their license suspended for 14 days. And third offense, they can have it revoked permanently. So some pretty stringent penalties for bars and restaurants who don't do the right thing. Section 5 is some insurance recording requirements. And I think this is huge. This is what I think will be the most effective thing and help the citizens of South Carolina going forward out of this legislation. And that's that it requires liquor liability, commercial and commercial general insurance policies to report data to the South Carolina General Assembly. And that means how many policies we wrote, how many claims we've got, what are our reserves, what's our profitability per claim, bunch of data, so that we just don't have to take an insurance company's word for it when they're raising our rates. This all started because insurance companies absolutely jacked up rates of bars and restaurants. And of course, their reason was, well, we're having to deal with all these lawsuits. But they provided zero data to back up that claim. And now, under this bill, we're actually going to get to see what they're talking about and see if they're telling the truth or if they've been pulling the wool over our eyes. So I'm looking forward to that data coming out. Section 7 is something called captive insurance. It allows bars and restaurants to collect their money together to create what's called a captive insurance company. That can do a couple things. One, it can let the good, responsible bars team up and decide who they let into their group and cover themselves because they know they're good actors. And hopefully it'll increase the availability of insurance available to bars and restaurants, thereby driving down their rates. Section 8 does a couple things. It allows bars to reduce their insurance requirements if they do good things, like close earlier, go to alcohol server training. If 40% or less of their total volume of sales is not alcohol, they get a benefit and they can drive the amount of insurance that they have to purchase down. And then the last thing is all of this takes effect starting January 1st, 2026. That is what the new law does. It fundamentally corrects some quirks in our joint and several system that I think unfairly targeted bars and restaurants. It does allow defendants to point the finger at others, which can be problematic and may cause some unforeseen consequences. And so while I think overall the bill is bad for victims, I think at the end of the day, it's a step forward in that we corrected some quirks in the system that unfairly targeted our hospitality industry. And please reach out to us. We're very familiar with this law and it will impact personal injury cases going forward. So I hope you've enjoyed getting caught up on what happened in this legislative session with our tort laws and our reforms that were passed by the General Assembly.